Have you been arrested in Indianapolis for a DUI? The next 24 hours, in fact, immediately when those lights come on from the police officer at the initial stop, that's when your entire case starts. So throughout the course of this video, I'm going to give you some do's and don'ts, if you will, of what to do, what not to do if you find yourself in trouble resulting in potentially a DUI arrest. And like I said a little bit earlier, the first thing that kind of kicks off the DUI arrest is the actual cop lighting you up. The cop's gonna knock on your window, license and registration. At that point, they're trying to gather information. Are you gonna fumble trying to get your driver's license? Are you going to fumble trying to get any type of registration? Can you do two different simple tasks, such as retrieve a driver's license from your wallet and answer very simple questions to the officer? So the first thing is, once you're lit up, don't try to talk yourself out of it. Once you're pulled over, in most instances, the officer believes that they have a reason to pull you over. And I'll get to that here in a little bit, but a lot of people, once they're pulled over, want to try to explain their way out of a situation. Hey, you been drinking tonight? No, I haven't had any to drink. Are you sure? I smell alcohol. Okay, maybe I had one or two. All that you're doing is you're giving the state more evidence to use against you. Officers are trained to ask these types of questions at the initial stop. So first and foremost, don't try to talk yourself out of anything. On the flip side of that, don't talk yourself into anything either. The best course of action is, if you're pulled over, just answer the questions that the officer asks you, and then don't offer any more information. You're not required to offer any additional information other than what the officer's asking. He's trying to get more out of you. The second thing is, if you are arrested for DUI, that does not mean you are convicted of a DUI. Sure, charges may be coming and a conviction might result in the future, but charges are just that. They are charges. They are allegations saying that the state believes that you operated a vehicle while you were intoxicated. That does not mean you have to walk in and immediately plead guilty or do anything to that effect. A charge is simply a charge. The other thing that a lot of people want to do after they're arrested is, when they get home, after maybe taking a shower, having a good meal, they're going to get on the socials. They'll get on Facebook. They'll get on Instagram. Whatever you can think of. And then they'll post, hey, I'm okay, or hey, I was involved in an accident last night, or something to that effect. Don't do that. Again, anything you say can be monitored by the state. And if you put something on Facebook, on Instagram, on Twitter, that's going to be reviewed and potentially used against you. So if you're arrested for a DUI and released, don't talk about your case to anybody but your attorney on that case. That way, you can control the information, you can make sure that the information is getting to who it needs to, the attorney, so then they can figure out with you the best plan to move forward. Now, another thing is, when you are arrested for a DUI, your license immediately becomes a priority and main concern. Why? Because when you sign up at the BMV for a license, one of the things that you sign is, if there's prima facie evidence that you violated or that you failed a chemical test, the BMV can go ahead and suspend your license. Now, that initial suspension is a 6-month suspension. That could be lengthened or shortened depending on further court order. But immediately upon a DUI arrest, your license becomes at risk. And if the court suspends your license, it's hard to kind of backtrack or to try to catch up to an order that goes to the BMV. Because now you have two government agencies working with each other, and you're trying to undo something that one agency did, and there's always some sort of a backlog. So it's very important that you call an attorney and that you get an attorney involved early for multiple reasons. Number one, to help save your driver's license. But number two, a lot of times there is some evidence that doesn't always get preserved. So for example, if you're pulled over at a busy intersection, you got a restaurant on one corner, maybe fast food joint on the other, Walgreens or CVS on a third corner, it's possible that there's video. And that video may be potentially helpful. The problem is, a lot of times that evidence is taped over. There's no auto record or anything. Oh, there was a DUI arrest, we have to save this. These surveillance cameras are set to basically roll over one another after a certain amount of time. So the longer you wait, the more likely it is that potentially crucial evidence no longer exists. But more importantly, I get this a lot. Hey, I don't have court for a month, for 2 months. I'm going to wait to hire an attorney until we get closer to court. That is a terrible, terrible idea. You want to get an attorney involved immediately following a DUI arrest, even if your court is weeks or months away for multiple reasons. The first one, as we discussed a little bit earlier, is preservation of certain evidence that could be crucial to help defend your case. The second reason is it allows us, the attorney, time to get everything we need to help save your driver's license, which the state will be trying to suspend at that first court hearing. So getting an attorney involved early allows you to kind of relax a little bit and allows you to have the best representation possible. It allows us as attorneys to gather the most ammunition and to make sure that you're not set up for failure. Rather, you're set up for success, and we're not trying to play catch up with a bunch of different entities. Now, this is all before our first court hearing. So kind of the process that we're looking at is once you're arrested and then charges are brought against you, your case gets set for what's called an initial hearing. And at that initial hearing, the judge is going to tell you what you're charged with, what the potential penalties are. They're going to enter a not guilty plea on your behalf, and they're going to get you some new court dates, and you're done. That's the essence of the initial hearing. I always tell people, I personally believe the most important thing in the initial hearing is for the court to figure out a game plan as to whether you plan on hiring an attorney or not. Now, hopefully, if you've made it this far in the video, you've already hired an attorney because you want that attorney to potentially have all the ammunition necessary to defend your case. And like I said earlier, just because you're charged with a DUI does not mean you have to plead guilty to a DUI. And allowing an attorney time to gather some of that information, because after that first initial hearing, the case will be set for various other hearings called pretrial conferences. Some counties will call them status conferences or attorneys only conferences. Ultimately what those are check-ins with the court to make sure that discovery is going okay. And discovery is just a fancy word for investigation to make sure that each party is getting their share of the files and everything to that extent. So a lot of times, those pretrial conferences are more, hey, how's things going and this and that. So we want to make sure that we have the time to get all that. But even more importantly, we want to make sure that during this time, you can still continue to drive if at all possible. So it's very, very important that you get somebody involved early on so then you can start taking the steps to lead you to that success. Because after the initial hearing, things like negotiation and continued investigation, depositions, things of that nature get scheduled so we can figure out the best game plan to fit your potential case. Now, I always say to people, hey, my job as an attorney is twofold. I got to get you to that proverbial fork in the road because a DUI case ultimately gets resolved one of two ways. One, there's an agreement with the state. Number two, the case goes to trial in some capacity. Now, that trial could be a jury trial. It could be a bench trial. Perhaps there's a motion to suppress because there's an issue with the stop or there's an issue with the field sobriety test. But in general, the case is going to get resolved in one of two ways. And ultimately, how the case gets resolved is entirely up to you. My job and our job as a firm is to get you to that fork in the road so we can have a legitimate conversation about the pros and cons of going in either direction. So having an attorney who's able to get all the information is always going to get you, once you get to that fork in the road, you're always going to be able to have that better discussion. You're always going to be able to have more options, or you're always going to be able to have a better conversation so you can make the best decision for you moving forward. So again, an allegation is just that. It doesn't mean that you are guilty. And then ultimately, at the end of the case, it gets resolved, as I said, by agreement or by a trial. That decision lies entirely in your hands. So don't make the mistake that a lot of people do and sit on their hands once they're arrested for a DUI and think, oh, I've got court coming up, it's not that important. Those people are entirely wrong. You want to make sure you have someone involved early. You want to make sure that you have someone involved that knows what they're doing and that practices in DUIs. So if you find yourself in a situation where you're charged or you know someone charged with a DUI, give us a call at the Marc Lopez Law Firm, 317-632-3642, so we can discuss your options and how we can best suit you moving forward. And remember, always plead the fifth.